The indoor management rule says that an outsider dealing with a company may assume that the company's internal procedures have been complied with unless something suggests they should look more deeply. The New South Wales Companies Code, which preceded the Corporations Act 2001, codified the indoor management rule in section 68 A. It listed the assumptions that an outsider is entitled to make. Subsection 4 said that a person could not rely on these assumptions if his connection or relationship with the company is such that he ought to know that the matter that, but for this subsection, he would be entitled to assume is not correct. In this case, Mr. Doyle and Ms. Arnhold formed Fiberi Proprietary Limited, which purchased a residential property which the two lived in. Doyle owned a group of companies, the Doyle Group, and his son was active in running the group. His son was director of some companies and secretary of others, but had no role in Fiberi. Without telling Ms. Arnhold, Doyle arranged for the Fiberi residential property to be mortgaged in order to secure 2 bank guarantees in favour of other Doyle companies. He used Fiberi's common seal, and Doyle Jr. fraudulently signed as the company secretary. Financial disaster followed. The bank called in the mortgages, and Ms. Arnhold sought to stop the bank by arguing that Doyle Jr. had no authority. The bank relied on the indoor management rule in the company code. Justice of Appeal Priestley held that the bank could not rely on the indoor management rule because it would have been easy for the bank to confirm the company officers and to realise that Doyle Jr. was not one of them. He said, a reasonably competent and reasonably prudent bank official would, as a matter of routine, have seen to it that the bank was in possession of information upon which the bank could rely, showing the identity of the duly appointed directors and agents of the various companies in Mr. Doyle's group, independently of Mr. Doyle's oral assurances. The obtaining of the information should have been a matter of no difficulty. The court also found that the nature of the transaction, Fiberi putting up its assets in circumstances where it would obtain no benefit, should also have put the bank on alert. The indoor management rule in its common law or statutory form is not there to protect willful blindness.